Hello, folks. Welcome back to Chris Wyatt Reports. News out of South Africa, where Davin Witbooi, the DA's chief whip in the Matsakama municipality on South Africa's west coast, has allegedly been trying to get residents to sign a petition to have an elderly farmer accused of attempted murder released on bail. This has become newsworthy because she's a member of the Democratic Alliance. I covered this story back in September when it broke, but the 70-year-old farmer Christoffel Stoman was arrested in September after allegedly running over 6-year-old Kwesi Jantjies and his mother while they were walking along the station road in the west coast town of Lutzville. The small boy sustained serious injuries, which left him with fractures in both legs, but he has since recovered well. Stoman is facing 2 counts of attempted murder, and his 2 bail bids in October and November were unsuccessful. Given the loose application of bail in South Africa for folks accused of crimes, one has to ask about the bail in this particular case for Mr. Stoman. Why has he not been granted bail? He's 70 years old. What's going on here? Are there legitimate reasons for not granting bail? Such as, does he have a criminal history? Is he a flight risk? Did his actions result in a fatality? Does he have a mental illness that makes him a potential threat to others? Is he a danger to the public based on his alleged actions? The answer to all these questions would, from publicly available information, appear to be no. So why was he denied bail? The treatment of suspects in South Africa and bail for them or denial of bail is wildly uneven and often unjust when it comes to skin pigmentation. Adding to the mistreatment of the accused is his claim that during a bail hearing that he has only 6 months to live due to a terminal cancer diagnosis. Now, News 24 has not investigated his claim, nor did they make any mention of how or if the court even addressed the claim. This in itself is puzzling and should raise questions. If Mr. Stoman is indeed terminally ill, holding him in jail while awaiting a trial that will almost certainly not occur in the next 6 months is inhumane and a clear violation of his human rights. He's not a convicted criminal. Normally, when someone is denied basic human rights, the South African Human Rights Commission is quickly on the scene, screaming in the press about the inhumane treatment of the South African. Well, unless the South African has been denied sufficient skin pigmentation at birth, that is. If Mr. Stoman is misleading the court, that can easily be confirmed with a brief medical determination on behalf of the court. Should that be the case, his potential untrustworthiness would be a genuine reason to deny him bail. But we do not know the answer to these questions because they have apparently not even been asked. Why? Instead, we have what certainly smells like either a racially motivated bail denial or an anti-DA campaign ginning up on the West Coast. When the media reached out to Ms. Witbooi for comment, she refused, stating, "I don't speak with the media. There are attacks on me and I don't want to talk to anyone." The DA's chairperson in the Western region, Koos Steyn, said that the party is aware of the allegations that their councillor was drawing up a petition to drum up support for the accused. So what? The councillor is doing nothing illegal or immoral. News 24 reports that Executive Director of the Rural and Farm Workers Development Organization, Billy Clayson, said that it appears that Witbooi feels that Stoman should get bail because of his cancer diagnosis and that this issue has been used for racial division. Now, Clayson's conclusions appear reasonable and are likely correct. Yet News 24's headline today reads, DA to probe allegations of its councillor petitioning release of attempted murder-accused farmer. Allegations of trying to get someone out on bail? Why? Why should the DA care about someone seeking bail for an accused? Well, it seems that we may well have the reason the Democratic Alliance might care. Racial division. Ah, yes, the selectively moral Democratic Alliance who fears profane language with a pathological obsession, but covers up for perverts. Now, Stoman is expected to appear in the Lutzville Magistrates Court this Thursday, the 12th of December. Folks, let's compare the Stoman case where he's alleged to have run over a mother and son, causing grievous injuries to the small child, to that of the horrific torture and murder of Brendan Horner, where one of the suspects was arrested for the crime, was granted bail. Both were eventually found not to be involved in Horner's murder, both the suspects of that murder. On October 1st, 2020, Brendan Horner did not return from a 20th birthday celebration. When his father and his employer went searching for him the next morning, a knife placed on top of his cap led them to his body, which was found some 400 meters from his home on the De Roots farm outside Paul Rue. Brendan was found tied to a metal fence post with a girdle and a woven black rope around his neck. He had stab wounds to his head, face, shoulder, arm, and hands, and appears to have been tortured and strangled. He had injuries to his fist, which suggested that he fought back, and scrape marks on his body, which suggested that he'd been dragged on the ground. An autopsy indicated strangulation was the cause of Brendan Horner's death. His baki was found some 15 kilometers away with bloodstains believed to be that of two different men found in the vehicle. On October 3rd, 2020, police arrested two suspects, Sekweche Isaiah Malamba, 32, and Sekola Pete Malalache, 44, at the Fateng Tse Ncho, a township outside of Paul Rue. Judge Dion van Rooyen found that a prima facie case existed against Malamba, who was not released on bail. However, Malach Saleh, who had a long history of previous convictions, was released on bail. He was, however, quickly rearrested on an unrelated stock theft charge. Judge Van Rooyen stated that aside from two statements obtained from witnesses, there was no evidence linking Malatsea to Horner's murder. He said there are no eyewitnesses, and the DNA results taken from the baki were inconclusive as far as it relates to him. Now, bear in mind, this statement occurred at a bail hearing nearly 3 weeks after they'd been arrested and detained, and in remarkably rapid fashion, South Africa's incompetent police service managed to test DNA despite having a backlog of 250,000 cases. They got this one done in just a few weeks. Now, Van Rooyen said despite the state's assertion that Malatsea had posed a flight risk, he had been attending his court cases in relation to two other matters. So on these grounds, I believe it's in the interest of justice to grant bail to applicant 2, Malatsea, according to Van Rooyen. So he wasn't a flight risk, according to the judge. Well, that's a fair assertion on his part. That's the same question I posed earlier in this report regarding Mr. Stoman, whether he's a flight risk or not. That's a consideration for bail. And in that case, in the Free State, the judge said he can grant him bail because he's not a flight risk. While making comparisons between circumstances of bail in different cases is an exercise fraught with peril, an objective observer cannot help but wonder why someone arrested for the brutal torture and murder of a young man is released on bail, yet an aged, purportedly terminally ill man is left to rot in jail. Shabir Sheikh is alive and well in his 15-year-long terminal illness. He is a convicted criminal and living free in South Africa. At the bail hearing on October 6, 2020, a crowd gathered and was later assaulted by SAPs who nearly ran over innocent people with an armored car. The angry crowd overturned a SAP's baki and set it alight. In that situation, Magistrate Buti Malangeni denied bail to Andre Pinar, a 51-year-old who was allegedly inciting unrest when the proceedings commenced on October 6th. He found that Pinar would likely interfere with witnesses and jeopardize the administration of justice. On the basis of what exactly did the judge reach that conclusion? Well, the Free State Court didn't agree. They overturned the ruling and set his bail at 15,000 rand. Now, Pinar was hardly completely innocent in the fracas and reportedly had a checkered past. But did his skin pigmentation play a role in his denial of bail? The only things that tie these two cases together, folks, are they're both situations of rural farm attacks or assaults. And there are markedly different treatment of the accused when it came to white South Africans. Mr. Stoman is accused of heinous action, but when other South Africans are accused of actual murder, they're set free on bail. Mr. Stoman may very well be guilty of running over the woman and child, but neither is dead. Now, that does not ameliorate the circumstances. However, equal treatment under the law is a hallmark of a legitimate society. When a legal system differentiates treatment of accused solely based on skin pigmentation, which some claim is the case here in America, when that is the genuine case, as appears to be so in South Africa, it ceases to be a legitimate system of governance. Jurisprudence dictates that all innocent, accused, and guilty must be treated the same under the law. Justice is supposed to be blind. When it comes to being accused of crime in South Africa, if your skin pigmentation is insufficient, far too often that appears to be a determining factor in whether you rot in jail or not. What say you? Thanks, folks.